snacks and goodies right back here. I mean, I would just say if anyone from the audience wants something, it's okay. Just go back, get what you want, and then go back and sit down, okay? Don't linger. Don't look at people's computers as you walk by. But happy to have anyone. And then also Representative Goddard did this out of the goodness of his heart. I did it because my phone went off yesterday, but I also wanted you to have a nice Valentine's Day. But Representative Goddard, also, we thank you for the snacks. Yep. So everyone, help yourself. We will go ahead and start today with a hearing on House Bill 2347, and I will call on Jason Thompson, our advisor, to give us a bill brief.
Madam Chair, you're just encouraging us to call your phone every single committee meeting.
I better make sure that it's off. Okay.
All right.
Jason,
Thank you, Madam Chair. As you mentioned, Jason Thompson, Revisor's Office. You have the short bill brief on HB 2347, sort of a continuation of yesterday's final discussion. We're again in the crime of theft, a little bit different approach this time though, and a little different theft of property. This one is about motor vehicles. So there are two changes that I highlight in the bill brief, and I'll show you where they are in the bill. The first change is there on page 1. You can see in lines 15 through 17. It's currently a crime to, with intent, as described in A, obtain control over stolen property or services, knowing the property or services to have been stolen by another. And the change in the bill is to make clear that obtaining control over stolen property or services, knowing or having reason to know the property or services were stolen from another. So the reason to know is really the key change here. It's a slightly different variation of the knowledge requirement, and I think the proponents will explain what they're going after with that change. And then the second change is to the penalty provisions. Hopefully you remember from yesterday's discussion, everything is currently based on value, right? With a certain exceptions for certain property that's not based on value. And you know, those range from at the top end, a severity level 5 down to a 7 to a 9. And currently it's a class A non-person misdemeanor when the value of the property is less than $1,500. So the new provision that's added on page 2 in line 16 would make an exception to that lowest level. So property that's a motor vehicle of less than $1,500, rather than being a misdemeanor, would be a severity level 10 non-person felony. So those are the two changes in the bill. Happy to answer questions.
Okay, committee, what questions do you have for the revisor? Representative Carmichael.
Thank you, Madam Chair. I hope I have only one question on each change contained in the bill.
Okay.
First, with respect to page 1, the changing knowing to or having reason to know. Has this language been utilized in other statutes so that we already have statutory construction, if you will, of what the difference is between knowing versus or reason or having reason to know? If you know.
Madam Chair, Representative, yes, that is a phrase used commonly in the law for one, but it's also used in the criminal code. And when we were drafting it, I know I looked up a couple of examples, but I don't have them at the tip of my fingers. And the proponents may remember too, because we did talk about where to get that language from and how it is kind of an established, even in the criminal context, it's still an established standard. Knowing or having reason to know is something the court can.
I will await the proponent's testimony. With your leave, Madam Chair, on page 2 of the change regarding less than $1,500 becoming now a felony. Definition of motor vehicle, I have a 1988 Chevy S10 Blazer that's no longer tagged, it's no longer operable. The only value it has is scrap metal. It may be worth $150. If somebody comes and tows that away, is that a motor vehicle, and hence $150 of scrap metal is a felony?
So, Madam Chair, my answer is slightly cautious because I know motor vehicle is not defined here. I'll go back and look in the general definitions of the criminal code.
You recognize why I'm asking?
Yes, so in KSA 21, it's probably 5111 or something. I can't remember the definition section. I'll look and see if motor vehicle is defined in the criminal code. I think it is, and if it's not, the more common usage of motor vehicle would apply. And yes, I believe that is a motor vehicle by all definitions I've seen. I don't think it has to be operable, to use that kind of more technical word. And I don't know if that's their intent, but I know the intent is to make it a felony for a motor vehicle regardless of value.
Thank you.
Do we have any other questions for the revisor? Okay, thank you, Jason. We appreciate that. We'll go ahead and hear from we have two proponents. We're going to go ahead and hear from Jan Jarman from the City of Wichita first, and she is on WebEx. Do we have her? Jan, are you there?
I'm here. Can you hear me?
Yes, we can. Thank you. Welcome to committee, and we can see you also. Thank you.
Oh, very good. Thank you, Madam Chair. Good afternoon to you all and to the committee, and happy Valentine's Day. My name is Jan Jarman, and I'm a deputy city attorney with the City of Wichita. I'm also one of the legal advisors to the Wichita Police Department. We thank you for taking time today to hear our request. This all started really talking about when a person's car is stolen and there are no witnesses to who actually stole it from their driveway. And there may be some video, but usually you can't see the face of the perpetrator. So when that happens, the vehicle is entered into NCIC, or a National Crime Database, and then it's stopped on the street, either with our flock camera system or just by pure luck of the officer. And often there will be a person inside the vehicle. Sometimes officers will see outward signs that the vehicle's stolen. They might see broken glass or a punched column, or maybe like no keys in the column. But there might be other credible evidence to show that it's a stolen vehicle. Often the person won't know who they got the car from. It might be Bubba down the street, no first name, no last name, no plan on where it's going to be returned, no day on when it's going to be returned. So that's a typical stolen car in the city of Wichita. And when the circumstances of the original theft are unprovable, then you drop down to the section number 4, which is basically proving that it's possession of stolen property, theft by obtaining control over stolen property. And what we're asking today are for 2 tweaks within that section that we don't think is changing the intent of the statute, but it allows prosecutors to use the statute as intended. The first one is that the prosecutor shouldn't have to prove what's in the mind of the thief. Because right now it says we have to prove the suspect knew the property was stolen. And we're asking you to move that to an objective standard of he knew, or we use the word should have known, but usually your statutes in Kansas use, as the revisor pointed out to us, reason to know. That the person in the vehicle had reason to know it was stolen. And that wording change would allow your jury to consider that outward evidence, the broken glass, the punch column. It would allow them to consider that they don't know where they got it from, when they're taking it back. And all of that would go into a jury's decision on determining whether that person had reason to know that that vehicle was stolen. So that's the first tweak we ask for in that sentence. The second one we ask for is that the statute currently only allows possession of stolen property to be charged if it was stolen by another person. So if a person is found driving a stolen vehicle, the person should have known was stolen. We have to prove that, again, going back to the original incident, that it was taken by a different person other than who's in the vehicle. And so the small tweak we're asking is take out that word by and replace it with the word from. So if there's a person found driving a stolen vehicle that they should have known was a stolen vehicle, then that it was that it was taken from another person. So we just have to prove basically that it was a stolen vehicle and that they should have known it. We think that's probably the intent of the statute, but it was just written in a way that makes it more difficult to prosecute. These statute amendments would apply to all thefts, though, not just vehicles. So if you took that same set of facts and moved it over to someone who's caught with say $5,000 worth of DJ equipment, the same factors apply. You know, the police are going to be looking for, are there scratched out serial numbers on it? Where did the person say they got it? Did they pay for it? How much did they pay for it? Did they pay a ridiculously low amount for it? You're going to be looking for those same standards of, should they have known that that was stolen? And then dropping to that second portion, we shouldn't have to prove where it originally came from. In that section, we're only trying to prove that they knew it was stolen property and that they possessed it. So that's the first request we have of you, is to change some of that wording to allow us to prosecute it as we think it was intended to be prosecuted. The second change really has to do with just the idea of it's specific only to motor vehicles, and that there going to be an amendment that any vehicle stolen, it makes it a felony. And the reason for that is people who have vehicles that are stolen that are worth under $1,500 or whatever, wherever we set the jurisdictional limit, it hurts them the most, because people with low value vehicles are people who probably are lower income. There are also people who don't have full insurance. They have liability insurance that's required by the state, but they don't, if their vehicle's gone, they don't have anything to cover them. So we think that this change would treat the crime as serious as it feels to the victim whose vehicle is stolen from them, because that loss can be very devastating. So that's really the crux of what we're asking today, is to get us back to a point where these are able to be prosecuted as intended, and that we treat stolen cars very seriously, even if they're a low value vehicle. And I will stand for questions.
Okay, thank you. Jan, I think we will go ahead and have the one other proponent, and then we'll let the committee ask questions of either you or Ed, if that makes sense.
It does.
If you can hang on. Okay, thank you. All right, I will call up Ed Klump to podium. Thank you for returning to our committee.
Thank you, Madam Chair. Thank you for allowing me to be here. And my name is Ed Klump, and I'm here representing the three associations: Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. The auto theft problem is a continuing problem in Kansas. From 2020 through 2023, Kansas averaged 8,373 motor vehicle thefts per year. That's an average of 23 a day, or one every 57 minutes. And while that total seems to be dropping in the last couple of years, it's dropping slightly, and we're still at a 5% above the 10-year average. It's also important to remember that many of these vehicles are used in other crimes. People will steal a car and use it to break into a building, go rob a convenience store, so that if some witness sees them, it was a stolen car that our witnesses are seeing, and we can't tie it back to them. So that's kind of another problem in that. In the second paragraph, Jan covered that very well. I just want to add one thing, and it's the last sentence in that paragraph. The term reason to know is used in 5 other criminal statutes. It's used in one traffic statute, and it's interesting that that traffic statute is about stolen antique vehicles. And I found a kind of a modification of that phrase used in probably 4 or 5 other statutes, but it wasn't applicable to what we're talking about here. It was used in ways that didn't make sense to use that here. In the last paragraph, I want to talk a little bit about this, making this a felony. And Jen covered that real well. I'm not going to duplicate what she had to say about our reasonings behind that. Last time I checked with the KBI, and it's been probably 3 years ago, 14% of the cars stolen in that year were under $1,500 value. I can assure you those are not all junk vehicles and things like that. I don't know, we couldn't make a breakdown of that, but if I was to make a guess, I would say from the data that we were given then, that probably about 3 or 4 of that 14% is probably that type of vehicle. And I based that on, I had a breakdown of what was below $500. I just don't have that with me. I think it'd be safe to assume under $500, you're talking about that type of a vehicle. If you're talking 500 to 1,500, you're probably talking about an operable vehicle. So that would leave about 11% or so, and that's a rough guess. I could get more exact numbers if we need them, that would apply to. Our reason for pushing for this is just what Jen stated, the damage that does to financially strapped families, that they have one car, they have no insurance to cover that car. And when they're without a vehicle, you know, if somebody steals my vehicle, I've got another one I can use while I get that one replaced. Not everybody has that advantage. It would make those a severity level 10, the lowest level felony. And keep in mind that as a severity level 10, those are presumptive probation unless you've got at least 2 prior person felonies. So most of these people are going to be getting presumptive probation. But it gets them on that felony grid where they belong. So with that, Madam Chair, I'll answer questions.
Okay, thank you. Committee, what questions do you have for either proponent, either one? Representative Carmichael.
Thank you, Madam Chair. Before I take the time of the proponents, I don't know if Mr. Thompson, we've been working late, if Mr. Thompson had a chance to figure out whether the junk vehicle falls within the category of motor vehicle for purposes of this type of law before we go any further.
Jason.
Thank you, Madam Chair and Representative. So I give myself credit. I did remember the right statute number for the definitions. It is 215111. I'm exhausted, but not that exhausted apparently. But there is no definition of motor vehicle in that statute, to my surprise. There is another criminal statute that defines vehicles, so that would likely be the first place you would look, you know, to another crime in the criminal code. That's the crime of odometer fraud, right? Acts concerning odometers. And it doesn't appear that there's any distinction between operable or inoperable in the definitions over there, nor does there appear to be a difference in Chapter 8, the vehicle statutes. It's usually more about whether it's required to be registered or not, rather than whether it's operable or not, if that makes sense.
Okay. That's amazing.
Okay, thank you.
Amazing work by somebody who didn't sleep last night, and I appreciate it.
True.
If I might inquire, I suppose, of Ms. Jarman may be the best place.
Yep. Jan, are you there?
I am.
Okay, thank you.
Thank you. I understand where you're going on the first part of your bill on page 1, but I want to return to page 2. I understand what you're saying about denying somebody transportation and therefore employment and therefore they can't feed their family. But that doesn't seem to be applicable to my 1988 scrap Chevy Blazer that I love so much. Would you all have a problem with us requiring that be an operable motor vehicle or a registered motor vehicle or something else so that it really focuses in on what you're trying to deal with, as opposed to something that probably ought to be dealt with under the scrap metal law if we just put vehicles in that law as well?
I absolutely agree with you, Representative Carmichael. In fact, I had that highlighted earlier today because I don't like the definition used in the traffic section. Well, I like it, but not for this, because everything is a motor vehicle there, like a lawnmower, everything that's self-propelled. So I do think that it would be a good idea to drop a definition into this statute of motor vehicle. So we're including cars, modes of transportation that work and probably that are over a certain size. I leave it to the revisor to give ideas.
Yeah,
here.
my second question was absolutely going to be about bicycles, tricycles, planes, and automobiles. I'd be glad to work with you over the weekend or whenever to get something drafted if you'd like. And I see Mr. Klump is seeking recognition.
Go ahead. Ed, go ahead.
I certainly don't disagree with that. I would caution that we have to be very careful about the words we use, though. Operable, then a car that breaks down on the side of the road, sitting on the interstate that somebody takes and tows off the 2025 BMW. of course, would not be fitting in this $1,500 range, but those vehicles would also be applicable. And those are the cars under $1,500 when they break down are probably going to sit there for a little bit while they find a friend with a chain that can pull them off the road.
Good point.
Registration, there's also caution with that. If we say required to be registered, that's one thing. If we say not registered, that's a problem, because then if I intentionally don't register my vehicle, even though it operates, and I drive it on the street once in a while, then it wouldn't be covered. So I think we'd have to be, I don't disagree with that, but we have to be very, very selective with the words we use.
Good, thank you. That's what we love to do in Judiciary Committee. Let's talk about words. Representative Osmond.
Thank you very much, Madam Chair. Question for Ms. Jarman. I wanted to find out, are you looking to go after pawn shops with this piece of legislation? And if so, what is the difference in terms of having reason to know between people that were to come into a pawn shop with stolen goods and those that are just desperate for money?
Wow. I didn't think about, no, I don't. We have pawn shop ordinances that are specific to pawn shops. And I think the law says we have to use the most specific ordinance. So I don't think this would be used for that purpose unless the pawn shop was taking vehicles. I guess if the pawn shop was taking vehicles that they should have known were stolen, I suppose it could apply to them. But it wouldn't have to do with the act of the pawn. I'm gonna have to think about that some more, but that's not the intent.
Okay. All right, because I just see as stolen, I understand that the second part of it is about vehicles, but it just really talks about stolen property. And yeah, so I am curious. Thank you.
Okay, thank you. Committee, any other questions for the proponents? Go ahead.
Would it be appropriate if I ask Ms. Jarman to look on the website and send me an email so that we can perhaps get in touch this weekend without me giving my cell phone number or her give her cell phone number? If you could, just shoot me an email. It's on the legislative website, and that way we can work on this.
Yeah, so Ms. Jarman, what Representative Carmichael suggested was you get in touch with him. Our emails, our work emails are on the website, or probably through Ed, either way. You could also do it, so, yep.
Great, will do. Thank you.
Okay. Okay, any other questions, committee? Okay, thank you. Are there any opponents or neutrals on this bill? Okay, seeing none, I will close the hearing on House Bill 2347. And we will plan to work this bill on Monday. As long as everything goes as planned, we will plan to work it on Monday, so you know. Okay, committee, we are now going to move into our working of bills. And I'm going to ask the committee to limit, just try to have like 2 bites of the apple. Like, we're going to have amendments, we're going to have discussion. I want to hear what everyone has to say, but let's, to some degree, try to have 2 bites at the apple. Just because I'd like to work 6 bills is what the goal is for today. Okay, what we're going to start out with is House Bill 2371. And Jason, if you could give us a little reminder about what that bill is. And while you're looking, we'll welcome Natalie Scott to the committee. Thank you for being here. It's a bill, or go ahead, you tell us.
Thank you, Madam Chair. No, I just couldn't find my bill brief, but I don't need it. This is the simple variation. House Bill 2371 is the bill about business entities. It has the revised Limited Liability Company Act, the Business Entity Standard Treatment Act, and the Business Entity Transaction Act. It's sort of the global update to things Delaware has done in the last few years related to LLCs.
Okay, committee, what discussion or amendments do we have on this bill? Representative Carmichael.
Thank you, Madam Chair. I have both discussion and an amendment. Well, with your leave, while the amendment is being passed out, I will go ahead with the discussion.
Explain it. Great, go ahead.
Thank you. As I think all of you know, there have been many discussions about this legislation that have taken places in forums other than the committee room. There is a group from Missouri who has introduced legislation under a different bill number that would impact the serial LLC aspects of this bill. That bill has not been heard. The proponents of that bill have not been subject to examination by the committee and good exchange of ideas about what's good about their proposed solution as opposed to the Kansas Bar Association's solution. Meanwhile, it seems everyone that I know of is in agreement that updating the LLC code is a good idea. The problem is just what Mr. Stafford described as he thinks it's grammatical. Others believe, Mr. Quick and Mr. Matthews believe that it is substantive. I think the best approach is to just, for the time being, take the serial LLC changes out of the bill. That way we get all of the good in updating the code, which everybody seems to agree about. And I know there are ongoing discussions last night, Wednesday, this morning, trying to reach a resolution, and unfortunately, a lot of it has probably been lack of communication, and maybe I'm at fault too. But the bottom line of all of this is we're really not in a position to make a determination in this committee as to which of two alternatives is best. So my amendment would remove the serial LLC provisions from the base bill, go ahead and pass out the principal bill. The parties can, presuming that it goes across the House floor, which I would anticipate it would, the parties can continue to work together, and if they can find a solution, then the Senate, in its infinite wisdom, or its finite wisdom, depending on how you interpret it, can put that agreement into the statute, and we can bring it across the floor over here, and we'd probably concur if they've worked it out. If they haven't worked it out, the Senate can take its best shot at it too, and one way or another, when the conference committee comes around, we'll get to where we need to be. If that process doesn't resolve it, then it would be an excellent issue for the chair of appropriate committee to give consideration to sending to the Judicial Council so that lawyers from both sides of this debate, half of whom have not been heard in this committee, can make their arguments, and maybe they can pound out an example that will not be detrimental to businesses in Kansas. So I would therefore move the amendment that is before the committee.
Okay, do we have a second? Representative Osmond, I saw first, so Representative Osmond seconds. Okay, committee, what questions or discussion would you have about the Carmichael amendment? Representative Curtis.
Thank you, Madam Chair. And could the maker of the amendment, could you please talk about the conformity to the Delaware, how that plays into this?
Right. I think if you will recall, our committee heard a discussion where what I've described as two of the preeminent business lawyers in this state from the Pocinelli firm and the Folston firm explained that if you deviate from the Delaware code, which is the gold standard, and I think even Mr. Stafford agreed that most people look to Delaware, that you run the risk that nonconformity and exceptions may provide traps for the unwary when they think that we follow Delaware law, but we don't. And meanwhile, businesses looking to come to Kansas, when they call it up on the listserv for lawyers, is Kansas Delaware compliant? The answer would probably be no, because we have some unique provision. Conversely, if you recall the testimony of Mr. Stafford, who is a really fine guy, but as he says, he's not a lawyer. He wasn't able to discuss what the actual differences or changes are that are proposed by this out-of-state corporation. And so we couldn't do a line by line or a meaningful comparison to find out if these are grammatical, substantive, or otherwise. And so we ought to do what's best for Kansas business, and that is adopt the update. If there's a serious dispute about serial LLCs, let's let the parties keep working, get to the right place. Let's not kill the bill today at turnaround. Let's get everything good we can on its way to passage. And hopefully the wisdom of the Senate, limited as it might be, Senator Goddard, will assist us. That's where I'm coming from. It's the only way I can figure out to resolve this a way that's not harmful to Kansas businesses.
Okay, committee, any other discussion? Representative Lewis?
Right, so I have had a chance to look at the, I guess it'll be my amendment, but it's language from the proponents of using the Illinois-Missouri model. And what I've discerned is that the amendment, the change, which we can talk about later, is, I wouldn't say it's semantic, but it's more clarifying and making sure that these series LLCs have the certain advantages that allow them to operate more efficiently. I don't see it as inconsistent with anything that is in the proposed Delaware language. It's just, as I said, sort of making sure that they also have certain advantages that are not inconsistent, in fact, are consistent with the language, but make it clearer. So I don't believe that we should, delay to have more discussion on this. I oppose the amendment.
Okay, Representative Osmond?
Thank you, Madam Chair. I seconded the amendment. I would support the amendment. I mean, the fact of the matter is that there are, frankly, a number of bills that come through Judiciary, which, let us be honest, we don't all know what is contained within the bill itself. We are trusting in experts in their field to help us, to guide us on the best decision to be made. So what happens when experts disagree? We may not have the capability to effectively hash that out. And I think that we should allow them to have that opportunity to hash it out. And if not, then punt it to experts that have that ability to do so, to better advise us. So that's why I'm supporting the amendment.
Okay, any other discussion or questions? Okay, seeing none, would you like to close on your amendment?
I would. I appreciate the remarks of my friend, the representative from Finney County. I think it would not be improper to say, though, that neither he nor I would be acknowledged as specialists in corporate law or LLC acts or serial LLCs. Now, maybe he does profess to have such expertise, but we have heard from two witnesses who clearly have the expertise, and they tell us these are substantive changes and they're damaging changes. We've heard from no expert on the other side. None. We've had no discussion about this language that's contained in another bill. And it would be imprudent on our part for me as a personal injury lawyer, defense lawyer, etc., to substitute my judgment for the only evidence, if you will, that we have heard, and that's the opinion of two of the preeminent business lawyers in this state. So this is the best compromise, and we should not substitute either our lay knowledge or our limited professional knowledge for the opinions of people like Mr. Quick and Mr. Matthews. So I therefore close and move my amendment.
Okay, thank you. Committee, you have heard the amendment on House Bill 2371. All those in favor say aye. All those opposed, no. Okay, we will do a division. All those in favor, please raise your right hand. Okay, thank you. All those opposed, raise your right hand. Okay, with that number, I think it was my count, 5 to 11, but that's not exactly, yeah, that would be right.
But would you be kind enough to record my affirmative vote in favor of my own amendment?
But first, I'm going to say that the amendment failed.
I apologize, yes.
Yeah. So yes, on the Carmichael amendment, Representative Carmichael votes yes. Anyone else want their? Okay. All right, we're still on House Bill 2371. Representative Lewis.
I have an
Okay.
amendment. I'd ask it be circulated.
Okay, thank you.
Yeah, yeah.
Representative, would you like to explain your amendment?
Yes, so I think the essence of the amendment, let's back up. Series LLCs, what are they? There's what I'll call a master LLC, which is sort of a parent corporation you could almost think of. And then under that, there are these, I'll call them, they're kind of like subsidiaries or series LLCs. And, you know, they have relationships and their operating agreement defines that relationship. And there are certain advantages that come with that. And I think what the proponents of this amendment are trying to effect with the amendment, which I'll get into explaining, is to allow for clarity in the law that they can use some consolidation measures, which would allow them more efficiency in terms of the operation of their businesses. Some of these series LLCs or series LLCs, you can have, I suppose, an infinite number of series LLCs, but I've heard that, you know, there are typically perhaps 10 or 12 series LLCs underneath the master's LLC. So if you look at the first page of the amendment, it sort of gives you a preface as to preface as to what the amendment's doing. It's saying that any of the series may elect to consolidate its operations as a single taxpayer and elect to be treated as a single business for certain purposes. And then it also permits operating agreements to impose restrictions, duties, obligations on members. And members, you can think of them essentially as shareholders of the LLCs. So those are the people with money, you know, invested, and specifying that wrongful transfer of property with intent to hinder, delay, or defraud creditors or to defraud shall be deemed void. So let's just take the consolidation. And that really amendment portion comes on page 31. And the operative language says the limited liability company, that's the LLC, and any of its series, so any of the LLCs under it, may elect to consolidate its operations as a single taxpayer to the extent required to file consolidated tax returns. So if they're required to file consolidated tax returns, they can consolidate its operations as a single taxpayer, which is kind of obvious that that would make sense, right? So they don't have to do it in a, with everyone filing separately. And then it goes on, it says, as permitted under applicable law, and they can also elect to be treated as a single business for the purpose of qualification or authorization to do business in this or other states. So typically an LLC has to register, get authorization to do business in a state. And once again, since you're talking about multiple LLCs, although operating under one umbrella, it would just make sense that they would be able to consolidate that effort and do it all at once. I guess once again, it's a substantive change, but it's not inconsistent with anything in the bill that's being revised or amended. It's just sort of adding some clarity. Going on to page 32, this has to do with the members, once again, or the managers. So members would think of them as shareholders, managers are people that manage the business. And this just says that, so if you read the sentence starting on the 13th line, page 32, at the end, an operating agreement, that's just the agreement that defines the relationship between and among the LLC, Master LLC, and the Series LLC, may provide that a member or class or group of members, once again, shareholders essentially, with the Series shall have no voting rights. So that's just saying the operating agreement can say that, or ability to otherwise participate in management or governance of such series. But any such member or class or group of members are owners of the series. In other words, they still have ownership rights. They're shareholders, but subject to an agreement, and everybody has to agree to it. You can say that the members don't have any management authority, which, in regular corporate law, certainly in larger corporations, shareholders don't manage the corporation. It's done by the officers and directors and so forth. So that's consistent with sort of Hornbook corporate law ideas. And then the last change, I think, is on the last page. And once again, this is just allows for some uniformity within the Series LLC operation. It says an operating agreement may impose restrictions, duties, and obligations on members of a limited liability company or series thereof as a manner of internal governance, including without limitation, choice of law, capital contributions, fiduciary duties, restrictive covenants, so forth and so on. So once again, it's providing, permitting, not requiring, but permitting that these entities operate with uniformity as within their group. There's a doctrine in corporate law called the internal government doctrine, which is, I think, recognized actually in Delaware law. It's case law, but this just sort of puts it into statute. And then finally, I would just say, I respect the fact that that Delaware is, well, I'm not sure I'd go so far to say it's the gold standard, but it certainly has a long history of providing guidance to the country's other states in terms of corporate law. But it's not without its problems too. I mean, not too long ago, Delaware Chancery Court, applying Delaware law, declared that the shareholders, the owners of a corporation, couldn't determine on their own how much to pay their CEO. And I've also read recently in Wall Street Journal that a number of corporations are now having second thoughts about incorporating in Delaware and are moving specifically many to Nevada and Texas. All states have their unique features, and that was recognized by the gentleman who proposed and worked on this bill, that Kansas does have unique features to its corporate law. This isn't particularly unusual that we would deviate. Well, I don't think actually deviate, but we'd somehow further clarify the law in this respect. So with that, I'll leave the discussion. That's my explanation of the amendment.
Okay, thank you, committee. You have any questions? Representative Carmichael.
Thank you, Madam Chair. Might I inquire, do you just want questions, or do you want questions and or discussion, or both?
Questions and discussion.
Thank you.
Go ahead.
Question for the carrier of the amendment. Unless my hearing aids fail me, I think I heard you make reference to the internal government doctrine. I thought it was the internal governance doctrine. Am I hearing you incorrectly or misunderstanding?
But I said governance. That's what I'd.
Okay. Well, it may be my hearing aids. I just want to make sure that we're clear. Now, discussion. This is not a red letter day for this committee. Seldom have I seen us adopt, in essence, a new bill without any supporting testimony at all. We're charged with the responsibility on this committee to make very important decisions, but we're not experts, particularly in these types of areas. And so I really urge my colleagues to think very carefully before you go down this slippery road of making these kinds of changes in the corporate or LLC code of Kansas without bothering to listen to the practitioners who know the facts. The other thing that I think the committee needs to be wary of is making our determinations based upon something we heard, something we read in the Wall Street Journal, or even worse, what somebody who took us out to lunch or out to dinner told us and persuaded us of outside the committee room. This is an embarrassment to the committee, Madam Chair.
Representative Osman.
Thank you, Madam Chair. I've dabbled a bit in LLCs. I know a bit about it. I've, in my time, written some operating agreements and some articles of incorporation, but frankly, even when we delved into this, I was unfamiliar with a lot of this, and frankly, I didn't know anything about Series LLC. I am agnostic on the concept of Series LLC and how it should be formulated. I'm not in support of the KBA for KBA's sake, nor am I against this proposal, even though it might go against the KBA. But I am, as the previous representative said, I am in objection to how we're doing this because we have not heard proponent and opponent testimony on this. And it is a very crucial and critical change that could affect a lot of businesses here in the state of Kansas. and we don't know enough about it to make an intelligent decision on whether to switch. And we don't have anybody that we can question on that by making the switch today. So thank you very much, but I will not be in support of the amendment.
Do we have any other discussion? Representative Barth.
Thank you, Madam Chair. I do have a question about the amendment, and I have worked for companies and worked with companies that have series, and I have also, worked with groups where you want to have we make changes that is bilateral, so it provides protections, because we are talking about folks, I know many of these people are members or partners within the organization, but they're not construed to be the management of that company. So I just want to verify that, when I see something here, when we're getting into these bullet points here on that page 38, just things like, I'm trying to read this to make sure I understand it, because we write law backwards sometimes. And shall not be construed to limit is in the current line 19. And then we're adding in these additional options like number 4, restrictive covenants, including non-competition, non-solicitation, and confidentiality provisions. Just those other things that are listed there, but that just kind of caught my eye as, are these normal in these types of arrangements? Because that I'm not familiar with. Thank you.
So if I might.
Representative Lewis.
So once again, this pertains to the operating agreement, which defines the relationship between the series LLCs and between and among the series LLCs and what I'll call the master LLC or the limited liability corporation. And these delineated provisions or areas pertain to, are dealt with typically in operating agreements. So, this would just say that the operating agreement could impose restriction, duties, or obligations on the members with respect to restrictive covenants. So, for instance, presumably, it could say you can't have a restrictive covenant, or that you would, it has to do with competition between and among the series. But that's very typical of the subject matters that operating agreements cover. And once again, I guess my point is that this is certainly not a radical departure from what we're already would be voting in favor of. It's more on the way of clarifying and delineating further detail with respect to the rights, duties, powers of series LLC operations. Then I might just, on another point, as I remember the hearing, Mr. Quick and I think it was his business partner, one or both of them were asked if they supported this, and they said no, but I didn't hear him give a reason. And I guess I would say, I respect their authority in the area, but I'd like to know why they oppose it, and I didn't hear that.
Thank you. Representative Williams.
Thank you, Madam Chair, and thank you for the carry of the amendment. I will start off by saying I am not a lawyer. However, I am a business owner, so it is very intriguing to see both sides of this table discussing and having some insight into, the issues that business owners now deal with every day. But I think as we look at the amendment, look at the testimony that we had, we did have proposed neutral testimony, and I believe in that it was stated that this language or concept of the language was brought to the Bar Association whenever they were reviewing the LLC laws or act. And when I look, being from a district that is closely bordered to state line, while I don't agree with everything Missouri does, I do think as we're looking at the business climate as a whole, it is good for us to have some type of semblance so that we don't foster any type of border war with our businesses, and we can be a more business friendly climate here in Kansas. And so I do think as a carrier of the amendment and this proposed amendment, there is no, substantive change. We may just drift away a little bit from the Delaware model. And from a business owner perspective, I don't think, going against the gold standard in any way is going to harm our state. I think we can look at how that has worked in Missouri and learn from that. And I do think that this is a good way for us to move forward to be more pro-business. And so I would consider this amendment good, and I look forward to supporting it.
Any other discussion, committee? Representative Curtis.
Thank you, Madam Chair. I'm real concerned about us moving away from the Delaware model. And I don't know if my notes here are correct, but it says that only Illinois shares these changes of moving away. I think there are many unintended consequences, and I would just reference the maker of this amendment to look at the testimony that we got from Bill Quick. He clearly outlines the concerns on that document, on his testimony of moving away from the Delaware model. And I did ask when the bankers were here to testify, I asked them specifically if they would prefer to stick to the Delaware model, and their answer was affirmative.
Okay, any other discussion? Representative Carmichael.
Thank you. Let me respond to two comments that have been made here. First, with respect, Representative Williams, I don't think that there was any testimony that what's contained in this amendment was presented to the Bar Association Committee for its review or comment. In fact, my recollection is that Mr. Stafford, who was nobody was in opposition, by the way, to the principal bill. He was a neutral, and he didn't know exactly what it was either. And so, no, this was not presented, I don't believe, to the KBA committee or considered in any way. But more importantly, responding to my good friend from Finney County, Mr. Quick is employed by the Pocinelli law firm of Kansas City, a multi-state national firm. Mr. Matthews is employed by the Folston Siefken firm with offices also all over the country, but principally a Kansas law firm. But more importantly, the testimony that we received, even the written testimony that we received from the Bar Association Committee, indicates that this is the combined wisdom of the Kansas Bar Association Study Committee, including William Matthews of Folston Siefken, Clay Barker and Jameson Beckner from the Kansas Secretary of State's office, Professor Amy Westbrook from Washburn University Law School, Rebecca Miller from Central National Bank, and Professor Alex Pratt from the University of Kansas Law School. So this is not two business partners coming in here saying this. This is the collective wisdom of the leading lawyers in Kansas telling you not to do this. Thank you, Madam Chair.
Representative Williams.
I do want to state that I said a concept. I do believe we heard that in testimony. So while it might not be the exact language, I do think that the issue was brought to them. So,
Representative, would you like to move your motion? Would you like to move your motion?
Yes, I move.
We have a second on the Lewis. Representative Williams seconds. Okay, any other discussion on the motion? Representative, would you like to close?
Yes, I'd like to close. One thing I failed to mention is some of the provisions in the amendment actually were approved by the bankers group, including the last one, which such elections shall not affect limited liability. I'm sorry. Reading wrong here. They were concerned about fraudulent transfers between and among the series LLCs, and the last clause in the last part of the amendment says the wrongful transfer of property from the series to another or the limited liability company as a whole with intent to hinder, delay, or defraud creditors of their just and lawful debts or damages, or to defraud shall be subject to KSA 3302-102. And I looked at KSA 33102, and it just says that it's void and of no effect. So this has also been vetted, I'd say, by our banking people. Thank you, and I close.
Thank you, Representative. So you all have heard the Lewis Amendment on House Bill 2371. All those in favor say aye. Aye. All those opposed, no. The ayes have it, and the amendment passes. Yes?
I would like my negative vote recorded, Madam Chair.
Okay, we will do that. Representative Carmichael, negative vote. Anyone else would like their positive or negative? Okay, thank you. Sorry, we're back on the bill. Do we have any more discussion on House Bill 2371? Representative Carmichael.
Thank you, Madam Chair. I think we made a terrible mistake here. Maybe the Senate will save the day. But in my judgment, the overall good to be accomplished by the bill, the parts which were not messed up by our bad decision, are still worth putting in the law with the hope that the Senate will exercise good judgment and bring us back to what's best for Kansas businesses. So I'll be voting aye on this, this principal motion and the bill as amended.
Representative Vaughn.
Thank you, Madam Chair. I don't want to be redundant of what's been said, but I think my primary issue with the amended version of this bill is that, you know, we didn't get to compare all the various series LLCs and decide of all of those, what's the best model for Kansas. We had one private company who wants to move to Kansas say, these are the changes that we want in the law to suit our needs. This is based on the needs of one private corporation, and we don't serve at the pleasure of one private corporation. We serve at the pleasure of Kansans for the benefit of the public good. And I'm not convinced that this bill serves the public good and the needs of Kansans because of that. So I think if we had the opportunity to do something like send this to the Judicial Council where they could review, you know, how can we update our laws to benefit businesses in Kansas and to have the best series LLC law compared to other states, you know, I think it would be a positive change. And as I think the bringer of that amendment alluded to, while the bankers did contribute to neutral testimony and make changes to the proposed amendment, I refer to the representative from Wyandotte County's comments that despite that, I think they would prefer the Delaware model, as was stated in testimony. So there are a lot of reasons to oppose this. I supported the underlying bill, but I just think there are too many suspicious things happening in relation to this amended version of the bill that make me really wary to support it. I'm worried about the tax implications of this amendment. I'm worried about the licensure implications of this amendment and just the transparency overall by which this amendment was brought to us. So I have a lot of concerns and I can't support the underlying bill anymore. So thank you.
Any other discussion on House Bill 2371? Representative Williams.
Thank you, Madam Chair. I move that we pass out House Bill 2371 as amended favorably for passage.
Do we have a second? Representative Lewis seconds. Any other discussion? Would you like to close, Representative?
I close.
Okay, committee, you have heard the motion to pass House Bill 2371 favorably for passage as amended. All those in favor say aye. Aye. All those opposed, no. The ayes do have it, and we have passed House Bill 2371 favorably for passage.
Madam Chair, may I have my affirmative vote recorded? My reluctant affirmative vote recorded, thank you.
Shall we put that in the minutes?
Not necessary, just that I voted aye before I change my mind when it gets to the floor.
Okay. All right, anyone else for their vote? Representative Barth.
I'm sorry. I just want to make a comment. So,
go ahead.
Madam Chair, when it comes to businesses, like, just so you know, I haven't been taking a dinner. I haven't done any of these things. I haven't talked to anybody specifically. I am just pro-business and anything we can do. And I've worked for companies like this that we can help them. I do trust the process of our senators too, being able to provide insight and input that can help in any way, shape, or form. The Judicial Council themselves are not businesses. They are attorneys, and so they don't know everything either in how things operate. So I do think we have to stick up for businesses and take in the experts' advice as well and balance that. So I just wanted to kind of mention that from my perspective of supporting this, and hopefully we could be pro-business to have good businesses here in Kansas. Thank you.
Thank you. All right.
Just for the record, I wasn't taken to any fancy dinners by any of the proponents of this
Okay.
bill.
Thank you, Representative Lewis. Okay, committee, we're now going to look at House Bill 2242. We heard that yesterday. Jason, if you could give us a little bit of a... And those who are leaving, if you would like some cupcakes and snacks, please help yourselves. Okay.
All right. Thank you, Madam
Okay,
Chair.
thank you. Jason, go ahead.
As you mentioned, Jason Thompson, Revisor's Office. So yeah, House Bill 2242 taught me a new word, retrocession. This is the bill about federal jurisdiction. The state of Kansas has ceded jurisdiction over certain property to the United States. And the proposal in this bill is to authorize the governor to grant requests from the United States to establish concurrent jurisdiction over some of that land, for purposes that they would agree to. The examples were prosecuting certain crimes or juvenile offenses, I think were the main examples given.
Okay, thank you. Committee, is there any discussion on that? Representative Carmichael.
Thank you, Madam Chair. This is good legislation, and with the chair's leave, I'd move that we report House Bill 2242 favorably for passage without further ado.
Thank you. Do we have a second to the motion? Representative Curtis, I think I saw you first. Representative Curtis, seconds. Okay, other discussion on this bill. Representative Osman.
Thank you, Madam Chair. I certainly don't want to kill the bill, but I think that this is the first time in the history of my experience in the legislature that the legislature has enacted a bill authorizing the governor to do anything or to expand her powers whatsoever. So thank you.
You're welcome. Any other discussion? Representative Goddard.
Thank you, Madam Chair. Based on my military experience, joint jurisdiction is very important. And in this case, when we talk about juveniles, the military treats adults. They don't treat juveniles. They have their own justice system, the Uniform Code of Military Justice, and that's what they primarily key on. And it was really great to have, if there was a juvenile that messed up, the local authorities could step in and take care of it. Thank you very much.
Thank you, and we appreciate your long and important service that you had to our country. Thank you. Okay, any other discussion, committee? Representative Williams. Oh, no, we've made, yeah. Okay. All right, with no further discussion, would you like to close on your amendment?
I greatly respect the ranking member's recollection of the facts in the legislature, but I suspect just this morning he voted for 3 or 4 bills that authorize the governor to enter into compacts. And with that, I close and move my motion.
Okay, committee, you have heard the motion to move House Bill 2242 favorably for passage. All those in favor say aye. Aye. Opposed, no. Okay, House Bill 2242 has been passed favorably for passage.
Please record my affirmative vote in the minutes, please.
Absolutely. Anyone else? Okay, thank you for that.
That was Carmichael's affirmative vote. Thank you.
I think we know who likes to have their votes recorded, but
Yeah, we do have a tape, though, that's audio only. People don't always get to see my smiling face. Yes.
Okay, good point. Okay, I think I'd like to do 2134 next. And Jason, if you could give us a little heads up on what that one's about.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. 2134 is the Open Records Act amendment. The proposed changes were to separate out charges for public records that are printed versus charges for electronic copies of records, account for how staff time is charged to requesters. And I think that pretty much hits the high points.
Okay, so I'll open this up for discussion or for amendments. Representative Barth.
Thank you, Madam Chair. I do have an amendment.
Okay, while they pass that out, would you like to explain your amendment? Or do you want to wait a minute so people can look at it?
Yeah, I can just tee up the amendment a little bit as they're, so it's not the technical piece yet, but just so everybody knows, in full disclosure, that this is something that was worked out by the Kansas Policy Institute and the League of Municipalities. And I did take two of the most critical rabbit hole digger, go through everything and request Cora requests on a regular basis. And we had a joint call this morning and I said, you know, I need these folks that have been doing these Cora requests on a regular basis. One of them is my constituent and one of them just lives in Douglas County, but not my constituent. Bipartisan type of review, and they both agree that this would help. Probably doesn't solve every problem, but does provide improvements from the process where we're at today. So I think everybody has it now, so I'll just kind of go through what it does. So page 2 there talks about the actual cost may include the cost to review and redact the requested records and not include the incidental costs by the public agency. So that's kind of the first thing it does. And then starting there on line 6, it's adding in if the public agency incurs costs for the staff, time to provide access to furnished copies of public records, the agency shall use in good faith the lowest cost categories. I think that's important that we're looking at the lowest cost category of staff so that it is saving the folks money and not using the highest, most category person to do these things. So it is looking at their salary and trying to find that lowest cost. And then starting there around 14, just changing within the executive branch of the state government. And then the biggest section there is on line 31, inserting in when the staff time needed to respond to requests will exceed 5 hours or the estimated actual cost of staff time at $200. And really what they're trying to do there, we heard in the testimony, is that we're trying for them to be able to make reasonable effort to contact the person to let them know, hey, this is a larger request, and to see if there's any other alternatives there. So it kind of goes in there just to really mitigate cost, to make sure that they've really gone through what it is that they're looking to request. I did learn some additional things that are not covered in here, but just FYI for anybody else that's listening or in this committee who may be making core requests, you can ask to get a breakdown of those costs and who and the hourly rates of those. So that is in your capability already today. And that also I've been told that, you know, sometimes the simplicity of the core request forms is not very easy, and that there's different ones, but you actually can use more of a simple, just create your own request as well. It's not mandatory from what I understand, and check me on that, Jason, if that's correct or not. But I think that you can, I've been told that one of them actually uses their own core requests as well. So that's outside of it, but I just wanted to share that as well.
All right, committee, do you have any questions for the maker of the amendment? Or discussion? Representative Carmichael and then Williams.
I don't mean to step in front of somebody
I'm
else.
sorry, did you have one? Okay. She's looking
Thank you
out.
for your assistance. I do appreciate it. I was heads down in the amendment. I do want the committee to be aware that I don't have major objection to this amendment, but I remain concerned not only the language of the amendment, but the principal bill at page 2 at lines 22 through 30, including the strikes and the balloon that goes right below it. Very few places do we have government where, for example, the Department of Administration, who may be producing documents, makes the decision and there's no appeal therefrom. I really think we still should have kept some avenue of appeal because I'm sure that Governor Kelly's Department of Administration will be abundantly fair And I'm sure that our next governor will, but I can't make those assurances for all time. And I really think we should have preserved some right of appeal, even to the courts if necessary, and even with attorney's fees provisions. With it, irrespective of that, I'll support the amendment as well as the underlying bill. Thank you.
Representative Williams.
Thank you, Madam Chair. I just wanted to get clarification that, I mean, some of the opponents were municipalities, but they were also representative, like sheriffs from different counties. And so were all opponents remedied, their issues remedied with this amendment?
The KPI, Madam Chair and Representative, the KPI and the League of Municipalities are the two that I'm aware of, in addition to some other experts, I would call them, in the field, but not the sheriffs that I know of.
Okay, but they were, this amendment did remedy their issues with the bill, the underlying bill.
Yes.
Thank you. Thank you, Madam Chair.
Representative, would you like to move your motion?
I will. And I'll also just add one more point too, is that you can even go on site, FYI, and look at these documents and see what's been redacted as well to review so that you can help mitigate your costs. That's actually already allowed. But I will move my motion to accept the amendments, please.
And do we have a second for that? Representative Barrett seconds. Any other discussion? I will just, my comment is I commend the parties that came together because we have heard this bill 2 or 3 times. And so at this point, they all came together, and the 2 groups that have been mentioned that kind of finalized everything, but there were others that also had input into those groups. And so this is, to me, a great example of not everybody probably got exactly what they wanted, but we did alleviate about 90% of what the concerns were on both sides. So I'm really pleased and thankful for them that they did that. So, okay, any other discussion on the bill? Representative, would you like to close?
Yes, I close.
Okay, thank you. Committee, you have heard the amendment. The Barth Amendment to House Bill 2134. All those in favor say aye. All those opposed, no. Okay, the bill has been amended. Now we are back on the bill. Any other amendments or discussion on House Bill 2134? Representative Williams.
Thank you, Madam Chair. I move we pass out House Bill 2134 as amended favorably for passage.
Do we have a second? Representative Ward seconds. Any discussion on the bill? Okay, seeing none, would you like to close?
I close.
So you have heard the motion to pass House Bill 2134 favorably for passage as amended. All those in favor say aye. Opposed, no. Okay, we have passed out House Bill 2134 favorably for passage.
Madam Chair, I ask that my affirmative vote on the amended motion or the amended bill be recorded in the minutes of this meeting. Thank you.
Representative Carmichael, well, we'll make sure your
Thank you, Madam Chair.
positive vote is recorded. Anyone else? Okay, way to go, committee. We have done 3 of 6, and probably some of the bigger ones. We're going to now go to House Bill 2323. It was the bill that we heard yesterday from the Insurance Department. Jason, do you want to give us a little heads up about that?
Thank you, Madam Chair. Jason Thompson, Revisor's Office again. 2323 is the Insurance Department's bill. It creates a new civil cause of action for fraudulent insurance acts. It also gives the insurance commissioner access to certain expunged records related to someone applying for licensure as an insurance producer or public adjuster. And it adds automobile assigned claims plans to the Fraudulent Insurance Act statutes.
Okay, what discussion do we have on House Bill 2323? Any amendments? Representative Carmichael.
I cannot recall, but I think I requested an amendment. I know I intended to, but maybe the revisor remembers. It appears that I did. Would it be kind, with the chair's leave, I'd like to have this passed out. Quickly, Madam Chair, what I was trying to accomplish here was there are civil penalties here. And what I wanted to make sure was that the insurance department doesn't have a financial incentive to go after people so as to obtain those penalties for its general budget. I want them to be compensated for investigative expense, the cost of pursuing the legal action, etc. But I don't think it's appropriate to give the insurance department an incentive to be bounty hunters. Instead, the appropriate place for this money to go is the state general fund for the benefit of everyone. We'd had that problem sometimes with our civil asset forfeiture statutes. Some people think that some agencies seize vehicles, etc., to make money. I don't think that's why the insurance department is wanting to do this, but I want to see us, just in the interest of making things appear fair to the people who could be stepped on by big government, to understand that this isn't a profit-making center for the insurance department. So that's my amendment.
Okay, thank you, Representative. I do have a question on that second piece. So is it just where it says department? Oh, into the insurance department service regulation fund rather than the department, sort of a technical, okay, got it.
Yeah, Madam Chair, just a technical correction. The name of the fund in subsection C1 is correct and not correct in C3. So when I struck the 1 in 1, I realized the 1 in 3 needed to be fixed.
Okay, great, thank you. Thank you for that. Representative Williams on the amendment.
Thank you, Madam Chair, and thank you for bringing this amendment. This is something that we have done with other budgets. So obviously, this isn't a revenue source right now that the insurance department is dependent of on their budget. And I do agree with the carrier of the amendment that we don't want to incentivize them to grow their budget through going after crime. Even though we want to be able for them to be able to be effective in what they're doing, but not incentivized through it. So I would support the amendment.
Okay, other discussion? Would you like to move your amendment, Representative?
Yes, Madam Chair, and I do appreciate the chair inquiring about the word department at the bottom there in the balloon. I thought that was the chair that asked about that.
Yeah.
Okay.
It was.
All I was going to say is I'd wondered the same thing when I saw it. Wait a minute, what's that doing in there? And I appreciate the clarification that that is a technical aspect. The substantive is state general. All that being said, I close and move my amendment.
Yeah, so not.
Oh, okay.
Just moving at the moment. Because do we get a second? Not yet.
Oh, you may be right.
So you're
right. Well, I will move. I will move
okay.
to amend the principal bill in accordance with the balloon amendment before the chair.
Thank you. Do we have a second? Representative Osmond seconds. Okay, do we have more discussion? Representative Bourgeon, did you have discussion?
Well, thank you, Madam Chair. I was just curious if the insurance department had been able to chime in on this. I understand that. I just was curious to know, but they're not here, so we can't ask them.
And I'll be honest with you, I requested the amendment yesterday immediately after the hearing and went on to other matters. So no, they don't know about this.
Okay, thank you, Madam Chair.
Any other discussion on the amendment? Representative, would you like to close?
I close and move my amendment.
Okay, committee, you have heard the motion to amend House Bill 2323, the Carmichael Amendment. All those in favor say aye. Aye. Opposed, no. The ayes have it, and the bill has been amended. Okay, we're back on the base bill. Do we have any other discussion on that? Representative Williams.
Thank you, Madam Chair. I move that we pass out House Bill 2323 as amended favorably for passage.
Okay, do we have a second? Second by Representative Ward. Discussion on the base bill. Representative, would you like to close? Seeing no discussion?
I close.
Okay, committee, you have heard the motion to pass House Bill 2323 favorably for passage as amended. All those in favor say aye. Those no. House Bill 2323 has passed.
Madam Chair, Representative Carmichael requests his affirmative vote be recorded in the minutes of this meeting. Thank you.
Would anyone else like their vote? Okay. Okay, we are now going to go to House Bill 2359. Jason, could you give us a little refresher on that one?
Thank you, Madam Chair. Jason Thompson, Revisor's Office. This is the bill that enacts the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act and the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. It also repeals the current Guardianship and Conservator Act and replaces it with this new Uniform Act.
Okay, thank you. I'll ask for discussion and amendments, and I do have an amendment on that one. So, yep. So if you all recall, during the testimony yesterday, there was a coalition that was concerned about the end of life section of this bill. They were in favor. They were opposition testimony, but they were in favor of the base bill, but they wanted more definition and more careful treatment of the end of life issue in our guardianship laws. And so this is the amendment that coalition of a group of, I think there were about eight groups that came together for that. So this is the amendment. It's a little bit, most of it, not most, a big piece of it is definitions. And so I think maybe I should just give you a minute to take a look at it, or go ahead and ask questions if you have questions now.
Quick question, Madam Chair.
Representative Carmichael.
I'm sorry, I know that we had Mr. Weber on behalf of the bishops, and I know we had Ms. Goodwin on behalf of Kansans for Life, but I do not recall who else was in that coalition you referenced. Could you refresh my memory?
Yes. Yeah. So it was the disabilities, Rocky. I've got the list.
It'd be Rocky Nichols, and it wasn't right. It was his associate, but there we go, Mike Burgess.
Disability Rights Center of Kansas. Then there was the Big Tent Coalition. The Kansas Council on Developmental Disabilities.
I've got it now, actually. Representative Bohai found the agenda and helped me. And the coalition.
We missed.
The coalition or the opponents, I take it.
Yes, they were the opponents on the bill because they felt like they could not support the bill if it didn't have this extra end of life.
I understand. I
language in
appreciate your courtesy. Thank you.
Yep. Okay, so yep. Representative Vaughn.
Thank you, Madam Chair. Did this coalition have a chance to run the language by the Judicial Council or their representative?
So I don't know if you all remember the discussion a little bit, but what Ms. Perner mentioned was they worked for several years on the big redo of the guardianship laws. And then towards the end of their work, this group came with their concerns. And it was towards the end, and there was a lot of changes that they were hoping to make. And the group felt like they could make a few changes. They could make sure there was a court hearing. They could make sure that there was an appointed attorney. But there were some other things that they felt like they couldn't get within the time frame because the Judicial Council meets the first Monday of December, and it was getting towards that time. So if you all recall, what happened was the Guardianship Advisory Committee made their report, And then the Judicial Council met, and we looked at all the reports from all the advisory committees. This particular report, we accepted everything except the end-of-life piece of the guardianship bill. And at that point, the Judicial Council said, it seems like those are policy decisions that might best be made by the legislature. So that's kind of how it all happened. And so they did, this group did put the language in front of the advisory committee, and they didn't have time, and they didn't agree with everything, and they did make some changes. And I will speak carefully for the coalition, saying, knowing what they went back and forth with our reviser, you know, it had to be in the form that worked with our statutes, and they've worked very hard to make sure that everything that they wanted was included, but yet it also fit in with our statute. So that's what we have here. Their concern especially was that that someone that was being kept alive by artificial means fit into the definition in that end of life section. And as we heard in the example, that like someone that had dialysis on a regular basis, they might be able to fit inside that definition. And so they wanted it to be very clear what the definition was of end of life and what happened. So what other questions or comments do you have? Representative Ward.
Thank you, Madam Chair. I just wanted to know if somebody could confirm with me. I remember when the Kansans for Life lady was testifying or speaking the other day, her concern was about hydration and nutrition, which I see in this amendment. Was that?
Yep,
all they
that
were
was part of it.
requesting?
And she had a part of writing the amendment also. Yep.
Thank you.
So I think that kind of a lot of the peanut is on page 11, which is our third page, and it's a definition of a person legally incapable of making healthcare decisions. So it makes it clear it's that's part of the definition that was changed. Again, clear and convincing was the standard of to be judged by. And what other questions might you have? Anyone else? Okay, if there's no other questions, I'll move my amendment, and I need a second. Representative Williams seconds. Any other discussions on this? Representative Carmichael.
Thank you, Madam. Thank you, Madam Chair. Once again, we have an example of serious legislation that will impact many, many lives that is about to be grafted into a bill that we've heard, but without any supporting evidence or discussion. Yes, from us, but not from the people who are the experts, nor have we heard from the people who practice in the field, work in the field, etc., who might oppose what's contained here. Instead, the House Judiciary Committee hears a bill yesterday, and within 24 hours, we now have, I would guess, 3 or 4 pages of legislation in balloons and other amendments here that nobody's looked at except a coalition that didn't even favor us with bringing their amendment into the room or putting it in their testimony what they wanted, so that people who might be in opposition or might have good ideas or might be able to fly spec this for errors could have input. Now, I'm not naive. I know that Kansans for Life is going to get their way in this legislature, but at least we ought to have the decency to listen to the other side. I can't make the arguments against this bill. That's not my area of expertise. But we had somebody here yesterday who could. But we didn't give her a chance to address this, no. We no longer have meaningful discussions in this committee like we used to, and it's a travesty, Madam Chair. Thank you.
Do we have any other discussion? Representative Lewis.
My recollection is she was in the room and we were having pretty open discussion. It wasn't like the chair was saying, "Oh no, you know, you've already had your say," and the group that is supporting this amendment also spoke, and she was the lady was here, and so I think we did have somebody here, if she was violently opposed to it, could have and should have spoken up.
Any other discussion? Representative Vaughn.
Thank you, Madam Chair. I just have a question. So I know the main concern was page, I guess technically 53, lines 41 through 43, and then onto the next page, that definition of end-of-life decisions. But then it kind of goes on to describe that legal process. So they have to get the opinion of a second doctor. There has to be the court shall review the written certification within 72 hours, et cetera, et cetera. So that part was stricken, but I just wanted to make sure that that was put back in the amended language in accordance with the changes that were made, so that those protections are still in there, but just possibly moved to a different place.
Yep, so it's at the end of our balloon amendment. There's several, it addresses it in a couple different places, but especially the end of the balloon amendment, if you look at C, I mean, it could be 2A, B, and then C. The court shall appoint an attorney for the adult. The court shall hold a hearing within 72 hours. The court shall not authorize withholding or withdrawal of life-saving treatment unless the court finds by clear and convincing evidence these things. So I'm sorry, it's on the, yeah. And that goes in right in that same spot where the strikeout language is. Okay, any other questions, or do y'all need another minute to take a look at it? Don't want to keep you from looking at it. Yeah, discussion? Representative Vaughn.
Thank you, Madam Chair. So in the balloon, it looks like they also added a cause of action. Is that correct? For injunctive relief?
Jason, can you give us an insight on that one?
Thank you, Madam Chair. Yes, there is a provision for relief if either a person is about to violate the section or you're seeking the court's determination that you should go forward with this and the person's incapable of making the decision. It's at the bottom of the big insert attachment. It would be subsection D3, if I'm reading it right. It's at the bottom of that big insert box.
Thank you.
Representative Bourgeon.
Thank you, Madam Chair. I just wondered, could you clarify for me, I believe the Disability Rights Center of Kansas, is that part of the coalition that you're referring to? And have they checked off on this amendment language to your knowledge?
They definitely did. So there was like something called the Big Tent Coalition, but they were just part of a bigger coalition that was the disability rights.
So it's not just Kansans for Life, it's the whole group. Thank you.
Mm-hmm. Representative Carmichael.
Thank you, Madam Chair. With respect to the allegation that has been made here, that the proponents of the principal bill should have addressed a non-existent amendment based upon conclusionary testimony contained in written testimony that undoubtedly was not available until moments before the hearing, is an example of what's known as sloppy lawyering. Thank you, Madam Chair.
Do we have any other questions or comments? Anything else? Okay. Okay, I'll close on my amendment. So you've heard the motion and second to amend House Bill 2359. All those in favor say aye. Opposed, no. The amendment passes. And
Like my negative.
Representative Carmichael would like his no vote recorded.
Thank you, Madam Chair.
Okay, now we are back on the main bill, which is a large change in our guardianship laws. So what discussion do we have on that bill? Any other amendments or discussion? Representative Carmichael.
Thank you, Madam Chair. It is with the greatest of reluctance that I will oppose this bill in its amended fashion. There's been a great deal of work done over a long period of time to try to reform our guardianship and conservatorship laws in this state. But when we make wholesale changes without proper transparency and without proper vetting, that will likely impact either my wife or my life or my mother's life one way or another, odds are, I can't approve of this. No is going to be my vote.
Okay, thank you. Any other question, any other comments or discussion on House Bill 2359? Do we have a motion? Representative Williams.
Thank you, Madam Chair. I move that we pass out House Bill 2359 as amended favorably for passage.
We have a second. Representative Ward seconds. Any other discussion, committee, on the bill? Okay, seeing none, Representative, would you like to close?
I close.
Committee, you've heard the motion to pass House Bill 2359 favorably for passage as amended. All those in favor say aye. Aye. Opposed, no. The ayes have it, and we will pass House Bill 2359 favorably for passage, and we will record Representative Carmichael's no vote. Anything else on that one? Okay, committee, I'm going to have to ask you to stand at ease for just 1 second, if you don't mind. I'm sorry, just a second. back in business, I will say. The first thing we're going to do is I'm going to call on Representative Bohai. Do you know why?
Madam Chair, I'd like to withdraw 25 RS 1089.
Okay, thank you. It is withdrawn. I think that's all we have to do, right? Yeah, just is that is withdrawn. So it was requested for introduction and it had an RS number and it kind of just didn't make it through the system in time. So the representative is withdrawing it. And if she so chooses at another time can reintroduce it. Yep, you're welcome. So that RS number is withdrawn. Okay, committee, we were going to work HCR 5008. We're going to wait till Monday to do that, actually. Just one little tweak that we have to make. So we're not quite ready to get that done. So that's all the business for today. But before you start talking, I'll tell you what we're going to do on Monday. We're going to work HCR 5008. We're going to work the auto theft bill that we heard today. And we may or may not work House Bill 2253, which is the livestock theft. I'm not sure, we need to see what people want to do about that. And if you have any suggestions or if you have any comments, talk to me or talk to Jason about that. Or also the auto theft bill for that matter. Okay, I think that's all we have. Don't forget that in the document room downstairs, they have the trivia contest about the presidents. It's due on Monday. So if you want to get a prize from them, and you'll learn a lot about the presidents. That's all we have. Happy Valentine's Day. Take some treats home to your kids. Anyone feel free to do that, and we're adjourned. Thank you.